welcome to the Chapter 2 video lecture. Chapter 2 is an overview of the United States legal system. So for Chapter 1, we dealt with historic context of the Constitution itself. Now we are going to discuss the U.S. legal system and the structure. So if we think back to last week, the primary goal of the framers when they enacted the Constitution was to protect and preserve the life, liberty, freedom, and fairness of citizens. And that's a really important part of law. Other things that are going to be discussed in this chapter are the different categories of law and the court system and the officers of the court. So starting off with the legal system and its operation. Law serves the goal of regulating human behavior and human interactions. And there are different reasons and justifications that are offered for doing so, including protecting society's interests, deterring antisocial behavior, supporting moral beliefs, upholding individual rights, preserving power for those who already have power, punishing those who break the law, and to seek retribution for those who have committed a wrong. And because the law is used to regulate these human interactions and human behavior in these ways, there are two predominant theories that explain the purpose, the goal behind the legal system. So consensus theory is this premise that we have all agreed to participate in a social contract to live in our society. So we give up some of our freedoms for the benefit and the security of everyone. And so this is the idea that we all agree what those basic values of our society are and what is inherently right and wrong because we're a part of the social contract, that all of our views are reflected, and the laws then express our collective values. So that is one premise behind the legal system. The competing premise, though, is rooted in conflict theory and critical theories. And this is that the laws that we establish and pass by society, their goal is to keep those with power in power. So the laws benefit and protect the interests of dominant groups in our society. So an example of this, so this doesn't mean that regular people fight. It means like pharmaceutical companies are able to, because they're a dominant, powerful group, are able to lobby Congress for benefits for their company that keep their company in a position of power, a position of authority. And those laws inherently don't benefit other industries or individual citizens. The purpose is to benefit a group that has power and control so they can keep the power and control. And the same thing would go for any industry that lobbies. That is kind of the purpose of it. So that's an example of conflict theory in action. Some other ideas about the purpose of the legal system are also discussed in competing models, the crime control model and the due process model. So the crime control model holds that the purpose of the legal system is to stop criminal conduct, and the criminal justice system needs to have tight control over all criminal behavior. And it needs to be efficient. Whereas the due process model emphasizes individual rights, presumes innocence, and believes that individuals' rights shouldn't be sacrificed for the sake of efficiency. So if more proceedings are needed to fully exhaust options or remedies under a due process model, so be it. That's the purpose of criminal justice, is to protect people. So we should fully exhaust all of our options. Crime control model does focus on expedience and moving things along, even if we do sacrifice a little bit of reliability that's acceptable under this model. So as we think about this, there are aspects of consensus and conflict theory throughout our society. They're competing because they both exist. And the same thing with crime control and due process. Both of these coexist at the same time, and they kind of are competing against each other. So at the end of the day, the basic purpose of our legal system is to ensure fairness and balance individual rights, but also prevent excessive government power. And so the scales of justice represent individual and societal needs being balanced out. So that's what the scales of justice actually represent. Your book provides kind of an example of how some of these principles can work together by using Roe versus Wade, and how this is the epitome of balancing out individual pregnant women's ability to terminate a pregnancy versus the societal need to societal morals and the societal goal of having a sufficient population. So kind of balancing those out is Roe versus Wade. And we see in that case, the Supreme Court says before a certain point it's unrestricted woman's choice. After a certain point, government can regulate. And since then, we've seen more and more government regulations be acceptable. But this is the idea of trying to balance everything out in the same case. Now, let's talk about the development of the law and some definitions of the law. So, we have inherited our law from England, and that law is called the common law. This is the idea that judges when they make decisions, they make laws and say this law applies to this situation, and that then becomes law, judge-made law. And so that in England was called the common law. In the United States, we call it case law, which is the idea that similar situations should be decided the same. Some of the legal principles of this are based on precedent and stare decisis. Stare decisis means let the decision stand. It is a legal doctrine that requires that the decision in one case should be followed in all later cases having the same or similar circumstances. So that's a lot of what lawyers do. They try and argue that this case is the same as this one, therefore this outcome should also occur here. And the goal of this is to ensure consistency in the law. Now, it can be problematic because if we get it wrong, then we have all these people getting an unfair outcome, and it also does make it hard to change as society changes. And if the balance of individual liberty and government power is askew in our cases, then we might need to kind of correct, which means a court would have to overturn itself and establish a new precedent that would be limited. Also, when we think about stare decisis, human nature and human behavior are perceived different, and so we also need to recognize that effective laws are those that are flexible enough to respond to changes in behaviors. An example of this, when the framers wrote the Fourth Amendment that protects us against unreasonable searches and seizures in our home, papers, and effects, they probably had no idea that this would eventually come to apply to our cell phones. And our cell phone, the mine right here, would be an effect that the Fourth Amendment would come to protect. But that's an example of our law being flexible enough to adapt to human behavior and societal changes. And so American law is called living laws because it's not stagnant, it changes, judges apply it differently, it expands or is even rescinded if it's no longer effective. So continuing on, we talked about common law and case law, which are kind of the same thing. Now we're going to talk about statutory law and the different types of statutory law. So statutory laws are set by a legislature or a governing body that has the authority, the jurisdiction to make a law. Sometimes this can be called codified laws. Um, and so codified law or statutory law is a law specifically set forth in an organized structured code, such as the United States Criminal Code, the Indiana Criminal Code, or a state or local ordinance. And remember, an ordinance is are your local laws, and these are either municipal or county level laws. Now, no statutory law can violate the Constitution because of the Supremacy Clause. And this has been a long-standing tradition in the United States dating back to 1803 in Marbury versus Madison. Now, Marbury versus Madison is the most important case in all of constitutional law because it is the case that establishes the Supreme Court's power of judicial review. So what happened is we at this point we're in a transition between the end of John Adams' presidency and the beginning of Thomas Jefferson's presidency. John Adams appointed Marbury to a position as a justice of the peace, which nowadays would be kind of more like a sheriff nowadays rather than what we actually call a justice of the peace. In Washington, D.C., the appointment met all the legal requirements of the appointment. Excuse me. It was sealed and delivered. It was sealed, but it wasn't delivered. When the next administration, Thomas Jefferson and his Secretary of State, James Madison, took office, they find the appointment, they don't deliver it, and Marbury sues them. He under an act of Congress, he sues the new administration for his job, and Thomas Jefferson wants to put his own guy in this job. And the issue is, can Marbury get relief here? And can the Supreme Court review an act of Congress to determine if it's constitutional or not? And the court finds that, for one thing, the Constitution is the fundamental law of the land. It is the basis for everything, and if a law violates the Constitution, it should not stand. And so when a statute conflicts with the Constitution, that the statute is just invalid. And the Supreme Court is the person who has the authority to evaluate and determine whether or not statutes are constitutional or not. If they are unconstitutional, they can say so, and the law needs to be taken off the books. So this is a really important case, and it comes right back here to no statutory law can violate the Constitution. So continuing with categories of law, we have another category is criminal and civil. Public wrongs are criminal, civil, private wrongs are civil. We often call these torts, but there are more types of civil law like family law and estates and trusts and contract law, business law. So because the victim in criminal is a community, the government's name is on the docket. United States versus Smith, Florida versus Smith, the name of a city versus a person. Now, crimes are acts that are defined by statute that are punishable. We have court felonies, we have misdemeanors, where torts are civil cases against one another, divorces, child support payments, things like that. And these cases are listed the name of the plaintiff v. the name of the defendant. There are sometimes overlaps between criminal and civil law. Some things are both criminal and a tort. Your book provides an example of a drunk driver. You can be guilty of operating while under the influence and also have a civil responsibility for the injuries you caused. Now, the next part of your book looks at citations. So, this citation is the way you find the law, and every citation has a volume number, abbreviation for the title, and a page or section number. So, for example, United States versus Miranda versus United States is Miranda v. Arizona, 384 U.S. This means it comes from the United States Supreme Court. It's on page 386 from 1966. when we're working on analysis papers, we will cite it this way. And this will also let you, if you go and punch this into Google Scholar, Ball State Library, it will pull the case up for you. Now, when you're reading a case, like your Supreme Court case for your paper, you're going to read a legal opinion. These opinions almost always contain the following elements. They have a description of the facts, a statement of the legal issues. They will provide the text or a paraphrase of the relevant law, statutory or otherwise. And then they will provide their holding. This is their answer to the legal issue. Miranda versus Arizona. Did his custodial interrogation without being warned of his constitutional rights violate his rights? Yes, it did. It violated these rights, and therefore we need that confession cannot be used against him. So that is the policy and reason. So a holding is the rule of law. That is what is carried over as far as stare decisis to other cases that are similar. When you read these, it's also important to know the terminology. The appellate court can affirm or support the lower court decision. They can reverse or overturn it or remand it, which is send it back to the lower court for a new trial or new proceedings. Now, a case brief is an outline of a legal case that contains specific elements, the name, case name and citation, a short summary of facts, the legal issue, the holding, and the rationale for the holding. If there are separate opinions, a case brief will also note those. So when you cite a case or you use references to track that case, sometimes this is called shepherdizing. So you can track that to figure out, has the original rule of law in Miranda versus Arizona been changed through subsequent appeals? So there are systems where you can use to track this out because you don't want to rely on a case that's been overturned or has been limited, like that circumstance has been excluded, because that is bad lawyering and you can get in trouble for it, and your client will suffer the consequences beyond you just getting in trouble. Now, so now that we've talked a little bit about some of the legal research and finding cases, let's talk about the court system itself. So courts have two predominant functions: settling claims between the parties and deciding what rule of law applies in a case. So Article 3 establishes our federal court system. What type of case each court can hear depends on its jurisdiction, which is authority to jurisdiction can mean the authority of a legislative body to establish a law or the authority of a court to hear a case. Now, our court system is two-tiered. We have a state system and a federal system. In the state and federal system, cases start off in trial court. They then move to appellate court if they're appealed, and the court of last resort in both systems are the Supreme Courts. If you think your rights were violated, you can continue to appeal your case to a higher court. We have multiple types of jurisdiction. Original jurisdiction is the ability to try, hear the case, and render the decision. This is the case, the times where you can hear the evidence itself, where appellate courts can just review the trial court's decisions. They're not hearing new evidence. They're reviewing the evidence in trial courts. General jurisdiction is a court that can hear a wide range of cases. Some courts have very general jurisdiction. They can hear anything under a certain value or over a certain value. Other courts can only hear juvenile cases or divorce cases, which would be exclusive jurisdiction. And there is concurrent jurisdiction, which is where two or more courts can hear the case. If that exists, usually the person who files first gets to pick the court that the case is heard in. Now, you can also try and move it through pleadings, but it may or may not happen. So again, state court, we have our lower trial court, appellate court, and our state Supreme Court. Federal courts, we have special U.S. courts. There are certain like bankruptcy courts and things. District courts are the trial courts. We have appellate courts. These are in districts. Indiana's in the 7th district. And then the court of last resort is the United States Supreme Court. Officers of the court include all of these individuals. Judges, lawyers, clerks, sheriffs, marshals, and bailiffs. Each one of these people have a duty to uphold justice, to uphold the our legal system and just to do justice. And now let's talk about the doctrines that govern what cases will be heard. There are 3 things that have to be met for a court to have authority to hear a case. The parties have to have standing. They need to have an actual interest in the matter of the dispute. If you do not have standing, you cannot challenge the case or the statute. If the actual interests have become moot, if they have been resolved or disappeared, you also cannot challenge the case unless it's the type of situation that will continuously re-arise, such as like a pregnancy. Even if you've given birth to the child, or you can still litigate out an issue that occurred during it because you can become pregnant again. Ripeness means the case came too soon. So you can bring it again later when the issue is actually an issue. So these all guarantee that courts don't get involved prematurely or too late, that they are involved in cases that actually have a specific dispute or interest that can be legally resolved. If that doesn't exist, then the courts do not have the power to hear the case. Now, components of the U.S. legal system. So courts, remember, we have to think, we're dealing with courts in this class in this semester, but courts are only one component. We also have law enforcement and correctional officers. We also have a juvenile justice system, and we have correctional systems that are in law enforcement structures that are all operating kind of simultaneously and are all impacting what happened in the issues we're working through this semester. All right, that wraps up the video lecture for chapter 2. If you have any questions, please reach out and let me know. I look forward to hearing from you.